Good afternoon. Welcome to the Waterstone weekly update. I've got my director Damien Grant, and we're going to be discussing a recent case, or relatively recent case, of the Commissioner of Inland Revenue and Clooney Restaurant Limited, which is a case that the IRD brought against a fairly reputable restaurant in Freemans Bay, Damien. So why don't you just give us a brief rundown on what happened and how the director could have done things a little bit differently and potentially avoided some liability here.
Yeah, it's a really sad story. So Clooney was a very popular and quite famous restaurant in Freemans Bay, which, Adam, you've confessed you've been to at least once.
I have, yes.
Now, Clooney's restaurant started in 2006, according to media reports. It closed down at the end of last year, run by a gentleman by the name of Tony Stewart. So we jump forward to 2014, and the restaurant is owned by a limited liability company. That company at this point owed the Commissioner of Inland Revenue Department $384,000, mostly for what appears to be PAYE and GST, unpaid payments. The Inland Revenue Department began liquidation proceedings against the company, and they served liquidation proceedings on the 15th of September 2014. 9 days after that, they entered into there was a sale and purchase agreement entered into. So there was a new limited liability company called Clooney Restaurants. His name was very similar to the old company name. And Mr. Stewart was the shareholder and director of the old company and the shareholder and director of the new company. He then did a sale and purchase agreement, and the terms of the agreement were this. The new company, Clooney Restaurant Limited, would take over all of the liabilities, not all of the liabilities, sorry, would take over $408,000 of the liabilities, which was all of the creditors except the Inland Revenue Department. Now, there was $411,000 worth of assets on the books for this company. So that $411,000 was transferred to Clooney Restaurant Limited, and Clooney Restaurant Limited said that they would pay $408,000 worth of creditors. There was $3,000 difference, which Clooney Restaurant paid across. Now, this left the Inland Revenue Department out of pocket to the tune of $384,000. Mr. Stewart subsequently put the old companies into liquidation with David Levin, which is kind of interesting because David Levin was often appointed by the Commissioner of the Inland Revenue Department. And in this case, the shareholders appointed Mr. Levin. We don't have any clarity on that, so we won't speculate. The Commissioner then took 3 causes of action against both Clooney Restaurant Limited, the new company, and Tony Stewart, the director. So, Adam, let's just talk about the first one, the Property Law Act distribution. So Section 348 of the Property Law Act, the Commissioner took action. What did they do and what was the result?
So the Commissioner took action against the new company, which is Clooney Restaurant Limited. Yep. It claimed that it had been prejudiced by the transfer of the assets of the old company to the tune of its debt, $380,000 in terms of its tax debt. So what they claimed was that because they were prejudiced, that the court ought to unwind that transaction and actually allow them compensation for that. And that's what the court did. The court ordered that the new company was liable to the old companies in the full sum that they were owed.
So, did the judgment made some song and dance about the fact that the old company was insolvent at the time that it did the sale and purchase agreement? Does that matter?
Yes.
So just talk through why the insolvency of the vendor company was important.
Well, the insolvency of the vendor company is important because it's one of the elements of the PLA disposition is that the company was or became insolvent due to that transaction. Or at the time of that transaction, sorry. So the rationale being is that it's only insolvent companies that ought to be set aside.
So if the vendor company was solvent, then there can be no prejudicial disposition because presumably all of the creditors were going to get paid. In this situation, the Inland Revenue Department was left out in the cold. Now, the other interesting element here, though, is you kind of look at this agreement and you think, well, what was wrong with it? I mean, the new company was saying, I'm going to get $411,000 worth of assets, and I'm going to take $408,000 worth of creditors over. So conceptually, what's wrong with that? I mean, they got the 411 worth of assets, which presumably was the fit out. What was the problem with this deal?
Well, the problem with the deal is that the new company's cherry-picked exclusively the debts that they want to take over, and by excluding the IRD, they've prejudiced their position. And the act is pretty clear, is that the applicant, which in this case the IRD, has to have a transaction by which they are prejudiced. And here it's clear, because their debt's excluded, they're not getting paid anything, or they're not getting the...
Well, they got nothing.
Yeah,
Yep.
under that transaction. So that's why the court looked into this, or the court granted these orders as being because they were prejudiced by that cherry picking element that went on.
And I think the other important thing to remember here is that for about 200 of that $384,000, this was for unpaid GST and PAYE, and under the Companies Act, that's what's known as preferential. So that money must get paid to any proceeds that come from that must get paid to the commissioner first. So here we have a situation where the $411,000 came in. It should have gone to the Inland Revenue Department first, but it didn't, so that was a problem. Now, the judgment there was against Clooney Restaurant Limited. They then went after the directors. The commissioner then went after the directors for breaches of the director's duty. So talk to us about that.
They did, and they were successful on all but one, and they had leave to pursue that last one. So the commissioner claimed breaches of Section 131 of the Companies Act, which is where a director has to act in good faith and the best interests of the company. Now, the judgment does not outline to us the specifics of how the director was liable for 131. I can't see the clear link in terms of a breach here. I mean, the new company it paid or transferred consideration, being the taking on of that old debt. So it's not clear to me how there was a breach.
I was surprised by that. So 131 is acting in the best interest of the company. I kind of struggle with that, because he wasn't acting in the best interest of the Inland Revenue Department, certainly, but I don't see that he was necessarily acting against the best interest of the company.
I mean, it could be the good faith element, that in doing this transfer before liquidation, the way it happened, that there's a lack of good faith in terms of how the director exercised his powers there, and perhaps that's how the judge saw it. But again, it's not elaborated on to great length at all.
And this case was not defended. At least in the hearing, it wasn't defended.
No,
so
it proceeded by way of formal proof, where the judge essentially assesses the merits of the claims and obviously finds them to be persuasive or not persuasive on the evidence he has.
So we're going to speculate a little bit in this, but what we don't have any visibility on the commissioner's submissions, and the judge hasn't elaborated on them, so that might be the issue. Section 133. Yep.
So that's the next breach that was claimed, and that's where the director must exercise his power for a proper purpose. In this case, he was found liable for 133 for the transfer to the new company. Again, it's not clear to me the exact reason why this was held to be a breach. It would have been useful to have a little bit more explanatory information of this.
Doing a deal like this that effectively favours one creditor over another, I can kind of see that that's potentially not using your power for a proper purpose. But anyway, Section 135, reckless trading. Now this one surprised me, because reckless trading is a pretty high hurdle.
It is a high hurdle, and there is, again, not a lot of explanation. It could be the fact there was historic tax debt of this company that was increasing over time, which may indicate that the director ought to have closed up shop sooner. That could be an indication of a continuation or pattern of behaviour that has increased the risk to creditors by not realising that sooner.
Yeah, it's curious. And then 136.
Yes, also 136, which is the duty to not incur an obligation unless you have a reasonable expectation you can meet that. Here, the obligations are clearly the debt to the IRD that was increasing over time and totaled about $380,000. So this seemed to me to be a stronger claim or breach of director's duties than the reckless trading claim. But
Yeah, because you can imagine a situation where a company director goes 2 or 3 months and they can't pay the IRD. That's possibly not a breach. Which Section 136 is incurring an obligation without a reasonable expectation that you can pay it. So if you miss a couple of IRD payments, that's probably not a breach of 136. But once you get to 6 months and you can't meet them and you continue to trade, I think that's a pretty clear breach. I'm a little bit surprised on 136.
yeah, so the judge here did not find breach of 136, but has reserved leave for the IRD to reactivate or come back to court on that issue.
Which kind of makes you what was in the submissions. Finally, 137.
Yes, also 137. So here the director has to exercise care, diligence and skill that a reasonable director would exercise in his position, and the judge also found there was a breach there. And I guess what this equals in totality is that the judge has held the director personally liable for the full debt to the IRD.
So let's just talk about that. So we've got the breaches of duties, 131, 133, 135, 136 and 137. Goodness, it went hard. But then, okay, so it's a two-step process. One, the director breaches duties.
Yes.
Now we come to 301. So what's the significance of 301?
So under Section 301, the court has the discretion to hold the director liable for a proportion or all of the debts of the company, and it's really up to the court how they balance and weigh, what proportion should be liable. Here, the judge found that the director was liable for the whole amount of the debt, so 100%, which is relatively
Which is unusual. Yeah. I mean, some of the significant cases on this, I'm thinking of Goatlands in particular, was kind of like 25%. So, and if you have a look at the deal that was done, you've got the 408,000 of other creditors plus the 386. You're talking about a bit shy of 800 grand. As a result of the deal, half the creditors were actually paid.
We're not sure if they were paid eventually.
Well, no, that's true. Actually, they may not have been paid in the new company, so we don't know that. Okay, now. There's a significant difference. So under the PLA disposition, it was the new company that had to pay the debt. Under the breach of duties, it was the director. Correct. So does that mean that Mr. Stewart was liable for 2 lots of 384,000?
No, it doesn't, and that's because the judge spelled out very clearly that the maximum recovery was to only be 384,000, or the total of what that tax debt was. There was no double recovery here. And it's a slightly interesting situation because you have the new company, Clooney Restaurant Limited, liable to the old company for the PLA disposition, and then you also, for the 384,000, then you also have the director, Mr. Stewart, personally liable to the IRD for the 384,000. So you almost have 2 different sets of liabilities flowing there.
Yeah, it's curious.
And the maximum recovery, like I said, is only going to be 384. So how that's divvied up or split up in terms of recovery, I don't know how that will work. But there is a ceiling there for that. Yeah,
because that's quite interesting. So on one hand, the commissioner said we want to hold the new company liable for the full amount, 386, and we want the director to be liable for the 384. Sorry. And the court says, yes, you can have both of those, but you can't have more than the total amount. And so that's obviously between the commissioner and the liquidator of the new company. Then we come to, but it's not over, Mr. Stewart. It just doesn't end. The heads keep coming.
I think you can say that the IRD took a kitchen sink approach, and they threw everything they could in terms of available remedies. And here, with this last cause of action, you see that approach really coming into full force. So here they also sought to hold Mr. Stewart liable under the Phoenix Company laws for the tax debt of the new company that he started up.
So, the Phoenix Company laws are really interesting. So under the Phoenix Company laws, which Section 386A of the Companies Act, and what that says is, if you're the director of a company that goes into liquidation, you cannot be the director of another company with the same or similar name. And so here we've got a company called Clooney, or variations of it. We have a new company called Clooney Restaurant Limited, and Mr. Stewart was the director of both enterprises. Now, in one sense, the company name isn't that relevant. The reality was that the companies were trading as Clooney's, and that was kind of the issue. So Mr. Stewart was the director of the old company, That company went into liquidation. The court then finds that he was the director of another company with the same or similar name, Clooney Restaurant Limited. Now, what was the implications for Mr. Stewart as a result of that finding?
Well, it was not good. So, what happened here when the court found Mr. Stewart liable for being a director or a Phoenix director, he's been made personally liable for the entire debts of the new company he'd set up. So it essentially adds to his liability. He's liable for $384,000 to the IRD for the breaches of his duties plus the PLA disposition, but he's also now liable for an extra $200,000 for breaching the Phoenix company rules. So it's really added a pretty large whack onto his gross exposure.
Yeah, so as you're right, as a result of that breach, he is now personally liable for the debts of his new company. And when he set up, so under the old company, he wasn't paying his tax. Under the new company, he also wasn't paying his tax.
Yes.
So not only does he have to pay the $384,000 from the old restaurant, he now needs to pay the $201,000 to the commissioner for the new company. Now, company directors are not normally automatically liable for their tax arrears. But in this situation, because he was running a Phoenix company, he was automatically liable for his tax arrears. So that was a tough break for Mr. Stewart. It's actually quite a sad story.
It is, and there were some ways that Mr. Stewart could have mitigated his liability, and if a different process was run, he may not have been automatically liable under the Phoenix company regulations for that new company's debt. So if he had run a proper restructure through the Phoenix regulations and he had purchased the old company assets through a new company and then notified the creditors of the old company of this fact, he could have escaped being strictly liable for those debts.
But he didn't. So let's talk about those. So under the Phoenix company law, and this is specifically allowed for in legislation. So remember I was saying that if you're the director of a company goes into liquidation, you cannot be the liquidator of another company for a same and a similar name. But there is there's a couple of exceptions. But the one we're going to talk about is this. In Mr. Stewart's case, he entered into a sale and purchase agreement, then he liquidated his company. If he'd done it the other way around, so what he should have done, or what the law allows him to do, the law allows him to put his company into liquidation first. Then the Phoenix company, the new company, could have negotiated with the liquidator to buy the assets, and the law says all or substantially all of the assets. So here you got a situation where Mr. Stewart, his new company, could have gone to the liquidator and said, Mr. Liquidator, can I please purchase all or substantially all of the assets? Now, had he done that, there's a couple of things that would happen. First, I don't think he would have paid $411,000.
No, I mean, you have to have some allowance for the fact that the fit out is not going to be very valuable, once the liquidation's gone through, and the likelihood of selling it for full book value is pretty low, if not zero.
Yeah. So, I mean, we do quite a bit of work in the hospitality space, and there is just no way we would get away with selling a fit out for its full face value. I mean, we would love to if we could get away with it, but the reality is it's incredibly hard to get that over the line. But the other thing, so the price wouldn't have been $411,000. So it probably would have cost him more in one sense, because he might have needed to pay some of those $408,000 worth of creditors. But he wouldn't have ended up paying the nearly $800,000 that he has as a consequence. But the other really important thing is, just come back to the Phoenix. It's a three-step process. So the first thing is, Mr. Stewart should have put his company into liquidation first before he did the SMP. Then he should have conducted an arm's length transaction with the liquidator, and the key thing there is arm's length. So the liquidator's going to try and get as much as they can, because that's what we do. And the third thing is, he would have needed to have written to all of the creditors in his old company, and so had he done that, he would have been. So then the creditors in the old company would know whether they want going to deal with the new company or not. So he would have been.
It's that simple, isn't it? There's
It's
only really three steps.
It's that simple. I mean, here at Waterstone, we do our fair share of those, and it's legal, it's allowed in the law. Had Mr. Stewart availed himself of this, he would have been in a much stronger position than he is then now. But even if he'd done that, though, Adam, would that have solved all of his legal problems in this case?
No, Mr. Stewart has very serious liability in terms of the IRD. He by not paying his GST and PAYE, he was in contravention of his obligations under the Tax Administration Act, and it's a criminal offence to not pay those.
Yep.
So it does not, having restructured in a different way would not have gotten Mr. Stewart out of this home free. He still would have had the lingering liability to the IRD for not paying those core taxes.
So it's not, the Freemans Company restructure isn't a complete get out of jail free card. There are still obligations that directors can potentially get into trouble with.
But this judgment here, the IRD received would have been very different.
Yeah, it would have been very different.
It wouldn't have existed potentially had he restructured it in a different way. His
liability absolutely would have been less. But the other really interesting thing here is that here you have a situation where, so this case was heard in the 2nd of March. Judgment came out a week later on the 10th of March this year. So here we have a situation where the Inland Revenue Department is not necessarily relying on the liquidators, although David Levin is one of their preferred liquidators. So we're not too sure of the arrangements behind the scenes here. But as a revenue was the only creditor in the company, that might explain why they were taking action, not the liquidator. But here you have a situation where the Inland Revenue Department is taking their own remedies against company directors for when they see behaviour that they don't like. Is this a cause of action? Is it only the revenue who can pursue these sorts of claims?
No, it's not. It's all creditors that can pursue these claims, and also liquidators. So Mr. Levin would have been able to take these claims had he so chosen to. There may have been an agreement that the Commissioner would take them instead, but a liquidator can also do these actions and claims.
But any creditor can. And so it's a really interesting point of case law. Right, so that's our Waterstone weekly legal updates. Thanks so much. We hope the rain wasn't too rowdy when it fell down, and we'll see you again next week.
Thanks for watching.